Right now, we will be discussing the need for and purposes behind a durable general financial power of attorney this morning with attorney Brian Ritter, Jr. He's with Byrd and Byrd, LLC. Good morning, Brian.
Good morning. How are you?
I'm fine. How about yourself?
Doing well, thank you.
Okay, what is this durable general power of attorney?
Well, a durable general financial power of attorney is a document where you, the agent, or you, the individual, appoints someone you trust to handle your financial matters when you can no longer handle them yourself, or if you just don't want to handle them yourself and you want somebody else to step in and do something for you.
Okay, well, who needs one?
Well, everybody needs to have one. It's imperative that everybody has one.
And what does it allow your agent to do?
Well, it allows your agent to do whatever you permit your agent to do in the document. So many powers of attorney contain a blanket statement saying that, well, my agent can do whatever I can do. But that's usually insufficient because banks and other businesses and financial institutions want to see the specific powers that you've specifically granted to your agent. And that's why it's so critical to state those specific powers that you've granted to your agent. Because if the power of attorney states the specific powers, it usually covers the standard powers, which include writing checks on your behalf, accessing bank accounts for you, hiring people to help you manage your real property and other assets, manage your retirement accounts, talk to health insurance companies, talk to Social Security, Medicare, the VA, OPM, and last, filing your taxes. But however, your power of attorney can be as extensive and inclusive as you want it to be. And a good rule of thumb is that you want it to be as inclusive as possible so your agent will not have any issues in the future when you need them to perform particular tasks on your behalf.
Okay, well, what if you're married? Can't your spouse do all the things that you'd like to have done for you?
Not usually. That's one of the most common misconceptions that I see in estate planning and elder law planning. So many people think that just because you're married that your spouse can automatically act for you, and unfortunately that's not the case. A spouse can only write checks for you on your behalf if you have a joint bank account with your spouse and only can access the money in that joint account that you both have. Just because you're married doesn't necessarily give that person the ability to write checks out of a sole bank account that you might have. Another example is if you own property, either in your own name or together, the spouse can't sell or transfer the house without a power of attorney or a court order because he or she would have to sign on your behalf, and unfortunately you don't have the capacity to sign for yourself due to some illness or mental infirmity. Also, your spouse can't talk to your pension company, your IRA custodian, your health insurance company, or even Social Security without some type of authorization from you or getting the court involved. And we want to keep the court out of this, and that's why a power of attorney is so critical.
Okay, so it's pretty important to have a power of attorney.
Yes, sir. It eliminates the need for the courts to get involved, and when the courts get involved, they appoint someone to make your financial decisions for you, and unfortunately, the court might appoint somebody who you might not want to make those financial decisions for you. Here in Maryland, there's no laws that allow someone to make financial decisions for you if you don't designate someone yourself. Maryland has laws on the books that allow for health care decision making, but not financial. So only the court can designate somebody to make those decisions for you, and that can take months, all while your bills are going unpaid and piling up.
Well, can I get a power of attorney online?
Well, that's another common question we get, and many people go online for their legal documents, but it's not always the best solution. Oftentimes, the powers of attorney found online are not as thorough as those that an attorney prepares, which can be very dangerous because many times we see people who did this thinking the document was sufficient, but when something bad happens and they came and talked to us, the power of attorney doesn't provide that specific authority that we might need to do some particular transaction.
Yeah, what are some of the important provisions not usually found in online powers of attorney?
Well, a lot of times in estate planning and elder law planning, the agent needs to be allowed to gift money, i.e. give it away to people. If the power of attorney doesn't authorize gifting, it can severely limit your estate planning options. Another one is safe deposit boxes. I don't know if anybody's ever tried to access a safe deposit box on behalf of somebody else, but it's like trying to get into Fort Knox. Power of attorney should have a provision specifically permitting your agent to access your safe deposit box and take the contents out. Because many people put their legal documents in their safe deposit box, and if your safe deposit box is locked up and your agent can't get to it, then you have to get a court order to access it. Another one is appointing substitute agents. Power of attorney can authorize your agent to appoint somebody else, a substitute agent or a limited purpose agent, if your primary agent's going to be unavailable, like they're going out of town for, a European vacation or something. So somebody else can step up and act for you if they're not here. And last, engaging in estate planning and asset protection. And many times a power of attorney doesn't allow for your agent to engage in estate planning, i.e. creating trusts for your benefit, or asset protection planning. And this is very important because if your health fails, it allows your agent to help preserve assets to either pay for your care or protect your hard-earned money, so you can at least leave something to your children.
Okay, we have about a minute left, Brian, and people tell me that just get a guardianship. Isn't that better?
No. Actually, guardianship is the most restrictive form of intervention because it takes a person's legal rights away to make decisions concerning him or herself. And during a guardianship hearing, evidence is presented indicating that the individual is not competent to make decisions regarding their financial affairs. So for a court to order a guardian appointed, there must be a finding of incompetency which bars the individual from making any further decisions for him or herself financially. It's a costly process because the court appoints an attorney to represent the person you're seeking the guardianship for, and you have to go to court and potentially put on a case if people are contesting it, and you have multiple people trying to seek the guardianship. And in a guardianship proceeding, the individual doesn't get to choose who will manage their financial affairs. The court does. And if there are multiple children fighting to be guardian, the most common result is the court will appoint a third-party neutral, usually an attorney, to be the guardian. And last, it's a common misconception, but the court is the actual guardian, and the person that the court appoints is an agent of the court. And therefore, the agent has to do an inventory of the person's assets and report every year how much money comes in from income and how much money was spent, and they have to account for every penny that was spent on that person's needs. Okay,
well, thanks for the information. We'll be checking back with you next week, okay?
Sounds good. Thank you.
Hey, take care now. Brian Ritter, Jr. with Byrd and Byrd, LLC, elder law lawyers with offices in Bowie and Prince Frederick, Maryland. Not just good lawyers, good counsel.